Hello.
There we go. I've got a response. How's it going, everybody?
We're doing. You're hilarious.
Right on, man.
Coming up there, like first thing is like, all right, holy,
Well,
this is good stuff.
I wasn't
Good
sure
stuff
whether
for
I was
Sunday
on or
afternoon.
yeah, I wasn't sure whether I was on or not. So anyway, yeah, because James isn't here. He's off running around with some girl, and he set everything up remotely. So I just ran the dogs to the park, and the screen was up, but I wasn't sure it was actually active till I saw the little. Every time I said something, the little green light comes on. I was like, "Oh shit, okay." So anyway, how are y'all doing?
We're doing all right. Well,
Yeah.
I am, anyways.
Right on, right on. I'm good. It's hot down here. It was in the 80s today in San Diego. We've got Santa Ana weather going again. Kind of unseasonal, but it's
Well,
about the
it's
right
supposed to rain
time.
this week, though. I think later in the week.
Down here, San Diego.
Well, I don't know. I'm in LA, but I think it's supposed to rain a couple of days, sometime this next week.
Oh man, I hope so. It's hot as shit right now. I hope it rains. I'd like some rain. That'd be nice. But anyway, so who is here first? I've got an hour tonight because I got to split right at 6. But we ought to just get to it. Whoever was here first, let's get moving. Or whoever has a question first, we can get right on it.
I just want to check my microphone is working. Can you hear me?
Yes, I can.
Okay,
hear
great.
you.
That's all I need right now. You can move
Wow.
on to the next person.
Loud and clear. So this is Lawyer
Great.
Up. Yeah, we got you very,
Yeah,
very
I got
clearly.
the microphone.
Yeah, it's working good. You sound great.
Good.
So,
Okay.
did you have any questions? Because I don't see that anybody else is jumping in to fill the void.
Not right now.
All right, all right. Looks like Missa just joined. How you doing?
Doing good. How are you?
Pretty good, just hot. It's Santa Ana. I don't know if it's hot up in LA or not, but it's hot down here.
My AC says that it's really cold over here.
Oh, well, if you have AC, then it should be cold if it's working.
Yes. So I finished the LSAT this week, and my
Oh, good.
juvenile case closed.
Oh, good. Congratulations. So when do you get your
Thank
LSAT score?
Not till the 29th.
Oh, okay, so it takes a while. Well, good
Yeah,
luck.
so thanks. I mean, it's done, so I feel relieved that I don't have to like really cram in a lot of studies. I feel good about it though.
Well, how was it in comparison to your practice exams? That's the big question.
Identical.
Identical. Shit, that's good.
Yeah, it was identical. Almost all. The only difference I really saw in it was just the style that it looked like. Just like the color formatting, fonts. But aside
Shit.
from that, it was almost identical.
That's great. So that means you were prepared.
Yeah. So I mean, I got a 157 the night before when I did a practice test on it, and 155 is what I needed.
Okay, well, hopefully you made it, right?
Right. Well, 140.
Go ahead.
Huh?
No, go ahead.
145 is what I needed to get into the 3-year program. A 155 is what I needed for the full ride scholarship.
Ah, got it. Okay. Well, hopefully you got that. That'd be nice.
Right. So, I mean, I just feel relieved that I don't have to do the tests anymore. I feel relieved that the juvenile case is closed. The last fuck you that the social worker had to me was to try to do the recommendation for joint legal custody between me and dad, and they lost that one too.
Well, that's good, right?
Oh yeah, definitely. I have sole legal and physical custody.
So what was their basis for wanting to do 50-50?
No idea. They didn't even explain that. Minor's attorney jumped on saying that there's past history of DV. Dad's attorney jumped on saying, well, it should be joint legal custody with mom having the tiebreaker say. My attorney came on saying, well, dad hasn't even come around for visits in the last year. He tried to put hits on the social worker, or he made statements about putting hits on the social
What do you mean he tried to put hits on the social worker?
He directly told the social worker that if he doesn't give him the kids back, he knows people, and it's not safe in California for him.
Oh, shit.
Right. And so my attorney put all this on the record. So the judge ended up ruling out that I'd have sole custody.
Damn, that's crazy. So was it the same social worker that was recommending Dad get 50-50? Was it the same one that Dad put a hit on?
Yeah, same one.
So what the fuck, man? Why would he do that?
Yeah. The only reason I can think of is that was the last fuck you to me on the way out. Like, Dad didn't even have joint custody, legal or physical, before the case even happened.
Damn, that's crazy. Well, maybe the guy was scared. Maybe he was worried that Dad really would put a hit out on him.
I mean, I feel like if that was the case, he would have had recommendations for a reunification not to be terminated. Yeah, no, I don't. I think that they just disliked me a lot more.
Yeah, that's freaking crazy. That's nutty. That's just nutty.
So,
man.
but it's done. So I just feel really relieved this week that LSAT practicing is done. The juvenile case is done. I'm already working on trying to find a new place. So
Good.
that's the next lineup.
Cool. Well, it sounds like you're doing good. How's your case going?
Right now, so we just did an extension of time in my case because the magistrate put a rush on all the different deadlines. Like, I think by January we should have end of discovery over.
What?
And that's really, yeah, I think it was January. Let me see. Hold on, I think I have it up in front of me.
Holy shit. Do you guys even have your 827 stuff resolved yet?
No, not yet. The only one who's even discussed the 827s is Gianni's case. Yeah, they had discovery cutoff for January 9th, 2024.
Wow. That's like no time at all. Period.
Right. Yeah, I mean, we don't even have any of the 827 issues resolved at all. So right now we did the joint stipulation to extend that. Now, the magistrate in Gianni's case, she denied the motion to compel.
Oh, okay.
But said that she would revisit the matter for months down the line if there's still no resolution on it. Susan, she wants to do a motion to reconsider and kind of point out to the Mark G case where you guys kind of signed off a stipulation on it and the magistrate granted it. So for some reason,
we haven't submitted the final one yet.
Really? We
Yeah.
saw in the dockets that the magistrate granted it.
No, that was the overarching protective order. Now we have a specific protective order coming.
Oh.
Yeah, there's a specific protective order that we're working on addressing the 827 records themselves. The first protective order is just for everything, right? But it's
Right.
not an order compelling production. Now
Right, but the difference. Oh, go ahead.
I was going to say now the next step is the stipulation to compel production by both sides, and that should be filed hopefully sometime next week or hopefully next week.
Right, but the difference between this case and the Mark G case, even if the magistrate hasn't signed on it, is that it's the same county council on record on one case saying, yeah, let's go and stipulate to this, and then in Janny's case saying, well, no, there's a juvenile court, they're the ones supposed to be the ones who do this. So it's kind of two different positions.
I would tell you to wait on that until we actually get our stipulation filed.
Right.
Yeah,
that makes sense.
Because if you come out saying that, she may pull out of my deal.
Oh, never mind, we're not saying anything.
Yeah.
It looked like it from our side that it was already done.
No, it's not.
I mean, just kidding. We weren't thinking about that ever at all.
Yeah.
Publish.
Yeah, it's not there yet. We're working on it, but hopefully it'll get resolved next week, and then you guys can do whatever you want.
Okay, so then I guess my first question up is, when's the cutoff for filing a motion to reconsider?
What you'll want to do, it's not really a motion to reconsider. It's in front of the magistrate, right?
Yes.
So look at the local rules on how you go about challenging a magistrate's order to the district court. Because you can object to the magistrate's order, and you just file the objection directly with the district court judge, explain why you're objecting and where you think the magistrate went wrong, and then the district court judge will make their own decision.
That's good to know.
Yeah.
I think they have Judge Bernal as the trial judge.
Who was the magistrate? Was it Pim?
No, I don't think so. Let me see. Annie. It was Alka Cigar, and so
Oh.
in that order, she ordered the stay.
Okay, so she stayed the case. Well, I mean, that's okay, I guess. I mean, gives you a little bit more time to pursue other things.
Right, right. And I mean, I kind of went back and forth with Susan on this. I said, I kind of don't mind the case getting delayed, especially if law school starting in January. Sure, give me some more experience between now and then.
Yeah, I don't think it hurts you guys to have more time. You know? So I would consider just sitting on it.
Right. I was just, okay, curious on your thoughts about that. Um, so, random question. I know it has nothing to do with the present time, but what do you typically look for in jury selection?
In jury selection, everybody has their different idea about jury selection. There's like literally volumes and volumes and volumes written on jury selection. There's a guy out there, David Ball. He writes a thing about jury selection. My view of jury selection is I don't want anybody on my jury that I wouldn't feel comfortable sitting down with and drinking a beer. And that means if they're uptight, I don't want them. If they have some weird frickin' quirk, I don't want them. I want smart people because I wouldn't want to hang out and drink a beer with an idiot. So a lot of like the personal injury guys, they want to pick the dumbest jury they can find because they're going to get in there and try and bamboozle them. But for this stuff, my feeling has always been these are complex cases. The legal concepts are complex. The nuances are complex. The other side's going to make a bunch of complex, confusing arguments. You need somebody that's pretty fucking smart to be able to figure all this shit out and weed through the crap. So that's my view. Is I like smart, well-educated jurors that aren't quirky or weird or politically fucked up. Basically somebody that I would be willing to hang out and spend a weekend with and maybe go to a barbecue, drink some beer, that sort of thing. I know that doesn't really give you a whole lot of guidance, but that's my view.
No, it does. It actually does. Yeah, right now I was just thinking about that when I was watching the Take Care of Maya case, and I was just wondering what are the qualities that you would typically look for in that. So
those are the qualities I look for, but like I said, every attorney, you can put 5 attorneys in a bag, especially on jury questions. Shake them up, you're going to get 15, 20 different opinions. Everybody's...
Do you have any example of questions you would ask?
It's going to be fairly specific to the facts of your case, right? The jury's going to get read. If you're in federal court, the jury's going to get read a neutral statement, just giving them a general idea what the case is about. And then what I like to do is just go straight into whatever my danger points are, my weak spots. Every case has a weakness, and I kind of want to know what people think about it. Like, maybe the client might have consented to entry into the home. Are you going to hold that against them? What do you think about that? Does that mean the government should be able to come in and just do whatever they want? Stuff like that.
Okay.
You want to address the weak points or your danger points with, at least in my view, you want to get the jury's view of, how they feel about the stupid stuff that your client might have said or done. And then if they're going to hold it against them, you kick those fuckers off your jury.
Right. No, that makes sense. That gives a lot of guidance. I know I'm like way down the line from that, but just curious about it.
Yeah, Decker Dog has a comment in the chat if you have it open, Missa, and that's absolutely correct. You want to look up, and he's written a bunch of books too, Nick Rowley, and he does a really good voir dire. Guy gets really, really good verdicts, but yeah, that's a good idea. Nick Rowley does good stuff. If you ever get a chance to see him, in action, it's a good thing to go watch. Has a very, very folksy, very, very folksy, down to earth style. Him and his wife are both pretty cool.
Yeah, Courtney's amazing.
Yeah.
They actually might be taking on my case. Hopefully, I need to talk to him again. But well, CZR. So Nick's old firm handled my accident.
Oh,
I was in the middle of that,
Gotcha.
and that was from they're so it's CZ now. The R's gone, but
Right.
CZ their financial guy is like a friend of my friend's. So yeah, they actually like handled my case and waived all their fees. It was really cool.
Oh, that's very cool. So
Yeah.
So what was it, like a car accident or something?
Yeah, I got hit by a car.
Oh, gotcha. Okay. Yeah, I know they do a lot of
That's
personal
awesome.
injury stuff. I think they actually handled the Gabriel Fernandez case up in LA a few years back.
Yes, they did.
Yeah.
They did with the family.
Right. Yeah, very cool. So
Well, and like and that's what I just did. I'm talking with the guy that did the documentary on the Hernandez case.
nice.
Yeah, I'm talking to him because my case kind of is like the flip side. I mean, you know that's not the extent of the incompetence that DCFS.
Yeah,
it's not just like
they're incompetent in every respect. It's on
they have
both
too much
sides.
power.
It's not even too much power. I don't even know if they have too much power. They're just all fucking incompetent.
Well, yeah, but I think they also have too much power.
Well, I don't know. The way the systems.
Well, compare. I mean, not that they shouldn't have those things, but it shouldn't all be in house, like a closed structure. Imagine if this criminal justice system worked like that. Like, first off, you have to get rid of the probation departments and the sheriffs, right? Because they do the jailing and aftercare. Let's make it all in LAPD, all in house. Now get rid of the centralized DA's office. You'll still have DAs, but they only work in the courts, and they work directly with the police that do the arrests and make the reports.
Yeah.
And let's give those cops a vested
hold
interest in it.
Hold on. Let's just stop right there. We're not here for a political discussion or a system bashing discussion. We're here for people that have litigation ongoing, that have questions or issues about how to deal with their litigation matters. We can open a different chat and have the political discussion, but it won't be much of a discussion because I'm not going to disagree with you. But that's not the purpose of the office hours here. So let's try to keep the politics and stuff out of it.
Okay.
And
I have a question.
Sure.
So with that, because my daughter is about to be 18 in a week on the 18th.
Okay.
And so so he would obviously have a claims also.
Well,
I don't know exactly what my question is.
Is your daughter back with you?
No.
Okay, she has her own claims. You don't have standing to pursue them. But
right.
I shouldn't even say she has her own claims. I don't know enough about your situation. But if she has claims at all, they will be hers to pursue and hers alone. And she's got 2 years from her 18th birthday to pursue her federal claims. Her state law claims, it depends on what her situation is. That statute may already be, or at least the government tort claims statute may already be blown. It depends whether she was adopted or got a guardian or what happened, what her status is. But her federal claims, those don't even begin to mature until she turns 18. Then she has 2 years from that date to file suit. But you don't have any say in that. You don't have standing to press anything.
Right. Yeah. Well, but I'm still her mom. Like, but so what if she was like not in a guardianship? I mean, she was just extended foster care.
Then her state law claims, the notice of tort claim, that filing requirement will be told during the entire time that she's under the county's custody. So if she is still under the county's custody and care until her 18th birthday, then she can still file a notice of tort claim her 18th birthday. She's got 6 months. 6 months to take care of that.
Okay.
Yeah, it just depends on her custody status.
Right. Yeah. No, she was just long-term foster care.
Yeah. So she
my rights haven't been terminated. Like, we're 4 years in, and we're still going to court every 6 months because he won't do anything.
Yeah, but the problem that you have is that your initial violation, since you're 4 years in, your initial set of violations all happened way beyond your statute of limitations.
Well, except for I mean, I don't know. I still think, I know you've never seen it, but I don't think you've ever seen a case like mine where I mean, the continuous violations doctrine, there's a number of doctrines that I would think that would appear that would, I mean, if nothing else, estoppel, just where they were stopped from doing it because justice demands it.
Yeah, I don't
Like
know.
every time I say anything, like they, I mean, that's like why I haven't seen or spoken to my daughter, but like twice in 3 years, like where it's all based on lies, all the way through.
Well, I mean that may be, and I'm not going to advise you one way or the other.
Yeah.
If you think you're within statute, file your suit, see where it goes. But yeah, other than that, so let's do this. Anybody else have any questions? Alyssa, Mike, I haven't seen you guys in a while. Nigel, I haven't seen you in a long time. Any of you guys have any questions or updates on your litigation status?
Can I ask a question?
You may.
Okay. So I filed my opposition to the motion to dismiss, and the judge is going to rule on that on November 20th.
Okay.
And I'm just wondering, what is the next step in the case after that?
Let me remember. You're the one, Michelle G. I think your case is down here in San Diego, right?
It is, yes.
And who was your judge?
Her name is Ben Siviengo. I don't know how to say it.
Benchevenko.
Yeah.
Are you actually going to have a hearing on it, or did she notice it as no oral argument?
Right now it says no oral argument unless she says otherwise.
Okay. So what's going to happen is she'll take it under submission probably on your hearing date. But
Uh-huh.
and this is just my experience with her. She may do something different with pro per plaintiffs, but
Mm-hmm.
it could be 3 or 4 months before you actually get a written decision after she takes it under submission.
Okay.
Yeah, so
I have a while before anything
well,
else happens.
you may. I mean, I don't know how she deals with her pro se plaintiffs. She may just knock something out really quick. I don't know. But have you had your scheduling conference yet or no?
Oh, not yet.
Okay, so what's going to happen is if you make it through the motion to dismiss, the other side will file an answer, and then you'll get an order setting what's called an early neutral evaluation and scheduling conference. The early neutral evaluation, the magistrate judge will give you like maybe an hour or 2 hours to try to settle the case. If you're not able to settle the case, then they'll just start setting cutoffs and trial dates, and that's basically it. Once that happens, you're off to the races. Until you have a scheduling order down here, though, discovery is stayed, so you can't do interrogatories, depots, anything like that until you have your scheduling conference.
Okay, so I don't have to worry about it for a little while anyway.
Yeah, you don't have to worry about it until the order comes out. Once the order comes out, things are going to start happening.
Okay.
Yeah.
All right.
Okay, cool.
And also, I wanted to tell you that I watched your Failure to Protect documentary the other night.
Oh, nice. I looked fat in that thing.
Oh, you did.
I think I did.
But I just, I thought it looked interesting, and then I turned it on, and I'm like, hey, I know that guy.
Yeah, that was a sad situation there. The way their case went there, that was a bummer.
Only one got their kids back, right? Only one of those families.
I think only one got their kids back. Yeah, and I just remember the skinny guy and the blonde lady, and that like totally split up the family, and just all this nastiness is really pretty sad. It was all based, it's always all based on bullshit.
Right.
And that's
right. Especially the one where the mother didn't know the kids were being sexually abused, but she somehow failed to protect them from that.
That's common. That is so fucking common.
Jeez.
I mean, that happens all the time.
Crazy.
Yeah.
She doesn't know. How can she protect something she doesn't know about? I don't understand that.
Happens all the time, man. People lose their kids over stuff like that all the time. Yeah. That's one thing. I mean, again, it's why we don't really have a debate. It's like Decker Dog was going off about how bad these guys are, and yeah, I mean, I don't disagree. There's really nothing. There's nothing to argue about. So,
And starting next semester, I'm going to be working with Respondent Parents Council in Colorado. So that should be
nice.
interesting.
Nice. So when do you finish? When do you finish law school?
May of 2025. So
All right. So you
I'm
got a
about
little-
halfway through.
Cool. That's very good. I'm excited for all you guys that are, taking this seriously and, knuckling down and getting in it. That's great. I think that's
Yeah.
awesome.
They said they were going to throw me in cases right away. So I'm kind of excited about that.
Oh yeah, you'll learn a lot, man. That's good. That's wonderful.
Yep.
So check in with us and let us know what happens once you get your order on that.
Oh, I will.
Yeah.
For sure.
Who's your magistrate? Do you know who your magistrate is yet, or no?
Allison Goddard.
Oh, I think she might be new. I haven't had anything in front of her. I don't actually even know who she is.
I think she is fairly new. She's only been there a year or two. But she seems, at least from the reviews I've read, she seems like a nice person. I don't know.
Well, you'll figure it out soon enough.
I guess I will.
So let me move on
Yeah.
to Alyssa, Mike, and Nigel. I haven't seen them in a long time. So who wants to say hi first?
I have Mike on the line.
Oh, is his machine not working?
Yeah, it sounds like he's having issues.
Oh, man.
Mike,
Can you hear me at all?
Yeah, I can hear you. How's it going, man?
Good, good. Just been a little busy lately. Thank you tonight. Mercy, did you want to go first?
oh no, I already went. All you.
Can you run me through, because I'm going to have to file the motion to compel at this point with the defendant.
Okay.
I was just wondering if you could run me through a high overview of what needs to be included, do's and don'ts, maybe some best practices,
Sure.
anything you could recommend on that. I've already drafted up my declaration, so if you could just run through that, I can kind of see what I have and don't have. And,
Yeah. Yeah, for sure. First thing that you're going to want to do, I know you're in state court, but many state court judges have their own chambers rules on how they want to deal with motions to compel. A lot of them don't like to deal with them, so what they do is they'll set up either an informal discovery conference or some other informal method of getting the discovery you need from the court without filing a motion to compel. So you're going to want to look at that first. If you don't follow their rules, if they have a preferred method and you don't follow it, the judge is going to shit all over you. So the very first thing you want to do.
Where I can find that information?
What? Say it again.
Do you know where I can find the particular process for this particular court?
Yeah, whatever court you're in, first you'll look at the court's local rules, and that'll be published on their website. Then you go to the specific judge's chamber rules, and usually they'll have like a list of judges with a hot link on the particular judge, and then you can go to that judge's little page, and then they'll have like their preferred methodologies, and some of them will actually have a link to a PDF file that has their courtroom rules. They don't all do it, but you always want to check to see whether or not they do it, because if they do and you don't follow it, then they'll just shit on you. Another thing that I'll do sometimes if I'm in a court, out of venue, my home venue, is I'll just call the clerk and I'll ask. I'll say, hey, look, I'm having discovery issues. Does this judge have some preferred method? Do they do informal discovery conferences? Do they have an ex parte process? Do they have something that they prefer we do instead of just filing a motion to compel? And the clerks will tell you. They'll say yes or no. And if they say yes, you say, okay, cool, where do I find that? And then they'll say where to find it, or they'll just tell you what it is. So that's generally how you would do that. Now, if you're just looking at a straight motion to compel, you got to comply with the meet and confer requirements before you do that. Otherwise, you'll get sanctioned yourself, even if you're right. So look at, what is it, like CCP 2016-010 or something like that for the meet and confer requirements, and you'll see that failure to meet and confer is a form of discovery abuse. So do not file a motion without at least attempting to meet and confer first. And if the other side won't participate in that effort, then you lay out in your declaration, in your supporting declaration, you lay out the efforts that you went through to try to, meet and confer and reach an accommodation, and then lay out the facts. They refused to participate or wouldn't return calls, or whatever the case may be. But you do that before you do anything else. Go ahead.
Real quick on that note, the defendant only listed an email and a disconnected phone number, and I haven't got any response via email, and of course I can't call them because their number is listed as disconnected. So I would just include that information when it references the meet and confer process attempt.
Yeah. And what efforts, if any, have you taken to find alternative contact information?
Well, I did do the background verification on the website. I did call the only other number that I thought was associated, well, that was listed showing to their name, but it actually went to their stepchild's phone, and I left a message with him to have them call me, and never got a call back initially back in the beginning. Mm-hmm. I'm a little hesitant to go through too many extreme measures because I'm being accused of harassment, and I don't want slippery slope of continuous harassment. So I think if I could speak to attempt, I think that should be suffice based on what the defamation claim is about.
Yeah, I mean that's fine. You just lay that all out in your declaration. The first thing in your declaration, you say meet and confer efforts. I can't meet and confer. I tried to meet and confer. They don't have contact info. The info that they gave to the court is bogus or gone or whatever. I mean, and you just want to detail whatever efforts you made to get a hold of this person. And number one, try to work out the problem. Number two, let them know, that you're going to file a motion on them. So as long as you lay that out and it's clear to the court that you made reasonable efforts, then you're not going to get hosed. So that's the first step. Second step, you need to look at the rules of court on filing motions to compel, and look at the particular underlying statute. Like if you're doing maybe a 2031, production of documents or something, each statute or subpart of each statute will have its own kind of requirements. But the rules of court are going to tell you specifically, and what you're going to want to do, it's got to be supported by a separate statement. That's a separately filed document. And in that separate statement, you have to lay out verbatim the substance of the discovery request, the substance of their response, and then a discussion, your argument basically, why it is that they should be compelled to respond further. And that's got to be for every single, discovery device that you're trying to compel. It's a very onerous job if there's a bunch of them. It's actually a horrible pain in the ass. Then separately, you're going to have a memorandum of points and authorities that cites to your declaration and your separate statement, but that's where all your legal argument is going to be. So you're basically going to have, three different filings. You're going to have your memorandum, actually four different filings. You're going to have your notice of motion and motion. You're going to have your points and authorities in support of your notice of motion and motion. You're going to have a separate statement in support of your motion. And then you're going to have a declaration in support of your motion. So you're going to have four different documents that you're going to file. And there may be exhibits attached to your declaration. Like, for example, even though you set out the verbatim substance of the discovery responses and objections, you're still going to need to attach a copy of the discovery device as an exhibit, the response as an exhibit to your declaration. So, yeah, doing a motion to compel is a big pain in the ass. That's why a lot of judges will have an alternative method.
Okay.
But that's all laid out. I mean, it's all laid out very, almost in a cookbook format in the CCP and the rules of court. And if you have access to a law library, there's a really good reference guide that we use. Actually, it's like the Bible for new stuff. It's the Rutter Guide, Civil Procedure Before Trial, and you just go look at the section on discovery or compelling discovery, and they just lay it out like a Joy of Cooking cookbook. Every step you got to follow.
And Rutter, is that Rutter?
Yes. Yes, Rutter. I think West publishes it. Thompson West.
About that.
Yeah, and also if you want, because I got my copy, you can go on eBay and you can find where they have the inserts, the paper without the folders, because it's 3 binders, but you can get them for like pretty cheap, especially like if it's like a year old. Like you can get, like right now you could probably get 22 and definitely maybe even 23 versions for relatively cheap, less than $1,000.
Yeah, that's a good idea, especially if you can get one fairly current, like 2021, 2022. Not very much changes in, civil procedure. So if you get a 2 or 3 year old version, it's not really going to hurt you.
Well, and even if there is changes, it's not to the format of things.
Yeah, right. For the formatting, it's
greatly.
not. Yeah, the
And
formatting
that's
is not
what
going to change.
mainly that is. Or there's also another series called that goes hands in hands. They also have one with the forms, and then there's one with there's the California Law and Motion Authorities. That's also Reuters. So it's a Thompson Reuters. But they've been in handy for me, anyways.
Yeah, those are very, very good. Everybody uses those. All the attorneys use them. The judges use them as a reference guide. You really can't go very wrong if you're using Rutter.
Okay, thank you.
Yeah, absolutely.
Now
There's another great book. It's O'Connor's California Practice. It's a civil trial.
Hold on, Decker. You gotta not cut him off when he's in the middle of a question. Use good radio etiquette, and what that means is when somebody else is speaking, you don't speak. You wait till they're done, and then go ahead and speak. I know that we all have it's a little artificial, so we all have a little trouble doing it, but let's just try to stick to that here. So, Mike, you were saying something? Go ahead.
Yeah, what I was going to suggest is try to, in lieu of the motion to compel, if I can request a motion for mediation to avoid any further delays, because I have a feeling that that's what's going to happen when we go back in February. Is they're going to recommend and send us to mediation. Is there a way I can request to have that ordered sooner than later? And if so, do you know what steps I need to take to request an order of mediation?
That's not something that I would do in lieu of a motion to compel. You have very strict jurisdictional guidelines on your motion to compel. You have 45 days from the time that you receive the defective discovery response. So let me ask you this first, because it sounds like maybe they didn't even respond. Did they not respond at all, or did they respond with shit?
They responded both times with, I guess what they call it is a boilerplate response without any specific detail. They sent basically a one-liner. It says, I object to the request for discovery in its entirety because it does not comply with the law concerning written discovery, including without limitations, CCP 2030.060, 2033.060, and 2031.030. Now I looked those up, and they were listed as one was like too broad of questions. The other one was, let me get back to it real quick here. One was grounds that it was irrelevant or not discoverable, and the other one was is not based on matters known or reasonably believed to be true at the time the response was served. So all my research says that they would have to require to respond with detailed reasons for their objection.
Right. So basically they just gave you shit responses. So this is one of those situations where there are strict time requirements within 45 days of the time that you were served those responses, you have to have filed your motion to compel. Otherwise, the court loses jurisdiction over the matter. It's a jurisdictional issue. So when did they serve that defective response?
It was mailed 10/26, so I got it about maybe a week and a half ago.
Okay, so you've
So
got
I would say I have till 11/26 to file my motion.
you've got 45 days plus they served it by mail. You said, right?
Right, so I get an additional 5, correct?
Right, that's right. So that's the basic rule. Make sure that is a hard jurisdictional cutoff. So if you don't have it filed within the 45 days, the court is jurisdictionally barred from determining the motion. So make damn sure that you get it done and filed, complete before that time period.
Copy that.
Yeah, that's critical. That's the most critical thing, is to get it done timely.
All right, that's good to know. That was pretty much all I had. So, I mean, and I forgot who was going to recommend another resource for me. Can you say that again?
Yeah, it's Decker Dog. Can you go ahead and share that with Mike?
Yeah, I was just saying that there's another practice guide that I really, really like. It's O'Connor's. It's a O'*CONNOR'*S, California Practice, and they have a civil pretrial. Like I even have the 2015. I just like the way that they lay it out. The rooters, like what Sean was talking about, is much more detailed and stuff, and they reference it in O'Connor's, but it's much more kind of user friendly, I think, for a layperson, definitely. Because it's one book, and it's just kind of more to the point without all the fluff of the actual statutes, if you refer to it as fluff. But it just makes it easier to comprehend and understand like what's going on. In my opinion, that was it.
Cool.
Appreciate that. So my two best sources are going to be the Rutter's Guide and the O'Connor's California Practice.
Yeah, and like I think I got my O'Connor's guide. I think I got it for like $30 or something on like Thrift Books. If you just put it in like O'Connor's California Practice, any of the books, if you just put it in, like do a search on Google, and it'll come up with stuff all over. So yeah, and Jones McClure is the publisher.
That's McLure.
Yes.
Thanks.
Cool.
You're welcome.
So what do we got? Elisa May and Nigel Bliss. I don't think we've heard from you guys in a long, long time.
Hi.
Hi, how are you?
Pretty good. I'm still waiting.
Still waiting.
Unfortunately.
Damn.
I'm still waiting. Yeah.
How long has it been?
Since, June.
June. Well,
Yeah.
July, August, September, October, November, December. Well, that's only 5 months. That's really not. I know it sounds like a long time and it feels like a long time, but it's really not. It's really not that bad.
I had a question on causes of action, and with medical record errors and them being requested to be corrected, and when they're not corrected, is that a new cause of action or like a continuing tort when it comes to negligence in medical records?
What do you mean the medical record's not corrected? You mean like in court reports, or in what respect?
So I had a chemical dependency evaluation done, and the caseworkers gave false information to the individual that provided the evaluation. Okay. And instead of verifying that information was correct, she just used it to switch my results that went from that I didn't have drug dependency issues to that I had drug dependency issues and required treatment. And she was told that the information was false, which it was, and I can prove that it was false. But she
was told by who?
The caseworker, the social worker.
So wait a minute. The caseworker gave them the information to begin with and then came back and said, oh, that was not true?
No, so the evaluation was done, and
Okay.
the results of the evaluation were that I wasn't drug dependent, didn't have a risk of being drug dependent. And then 2 months later, the caseworker, because the judge had said that they were going to close the case,
Uh-huh.
she needed a reason to keep it open. So
Uh-huh.
she went and contacted the evaluator and gave her false information. And she put that into my evaluation and changed it without notifying me or even asking me if the information was true. And resulted in me having to go to treatment and changed the results of the evaluation to a risk of drug dependency
Okay.
based off of information that wasn't true.
Okay, and then based off of information that wasn't true, that information came from your caseworker.
Correct.
And your question then is, can you loop in to your claim the evaluator?
Right. Because I've requested them multiple times to have it fixed.
And they won't
information
do it.
taken out, and they won't do it. They
Now,
haven't done it.
have you already demonstrated that it was false, the information that your
Oh, yeah.
caseworker?
Yes.
How did you demonstrate that?
When we went to court, and this is when I didn't know that the evaluation had been changed, and so we went to that court hearing where the judge was going to close the case, and that's when I found out, because the caseworker had stood up and said they didn't want the case to be closed because I was non-compliant with the treatment recommendations that I was given,
Uh-huh.
which I wasn't given any treatment recommendations, and so I was confused by that. Well, that's when I found out. I called them, and she said that she did change it based off of this information. And I told her, well, that information is false. And this is 2 months after she had already done the evaluation. And I told her how it was false, and I offered to provide her information to prove that it was false. And she hung up on me. She said she wasn't going to lie to me or not going to argue with me. And she hung up. And that was it. She wouldn't answer any more of my calls. I called her supervisor.
Yeah,
let
fuck.
her know
I think the way I would go after something like that is, you sued the caseworker already, right?
Right.
And it was some sort of probably a judicial deception claim, something like that.
Oh, yes. It was multiple.
So
Yeah,
what
different things.
I would probably do is the evaluator, I would just add her in as a co-conspirator. A joint
Yeah, I did.
joint participant in state action to deceive the court. It's not
That's right.
it's not a negligence claim. She really fucking did it, and she intended to do it. And when you asked her to correct it, she said no.
Right. Okay.
So that's
I did include them in there. But
Yeah.
they said that it should have been a separate lawsuit filed, that it shouldn't be included with my
I don't think
1983
so.
lawsuit.
I don't think so. I mean, she made a fraudulent record, right? She made a fraudulent report that she knew was going to go to court to help out this social worker. What would be the separate lawsuit?
And she also said that because the caseworkers' future acts exempted them, it exempted they did, so it made them not liable. And then they also said that because they didn't know the information was false, she had no reason to believe. But that's when I put in with my response. I said that she did know because when she called my phone, I had a call recorder because all of my calls with the caseworkers were recorded
Yeah.
because they were lying so much. Well, she called my phone. So that whole conversation was recorded. and I put that in there.
Wait. When you say she, who's the she that called?
Oh,
your
sorry.
phone?
The evaluator.
Okay.
Initially, I had first called her and
Uh-huh.
then left a message, and she called me back
Okay.
about the information being false. So when she called me back, and I told her, and when she hung up on me, that whole conversation was recorded, and I put that in my response when they said that, she wouldn't have known because she didn't know the information was false. So that kind of shows that she did know. Well, then they said that because I didn't ask her permission to record her, that they could sue me now for recording her
Well,
without the permission.
I think you're in
Permission.
Montana, right?
Correct.
Are you guys a two-party state or a one-party state, or what are you?
It's a two-party, but I believe that if she was calling me, I think it's different than me calling her.
Hmm.
I haven't really looked into that.
Are they threatening to sue you for it?
They said that if if that recording is used, then they have the right to sue me. guess.
Well,
Because I caught him lying, so I guess they're trying to scare me.
Right. I don't know. I would think about that bridge after I crossed it. I think the hurdle in front of you right now is you've got that pending motion to dismiss, right?
Right. Yep.
And you already added this other lady into that complaint, the one that's pending, right?
Correct. Yep. Yes.
Yeah. So I think it sounds like you've done the right thing. Just loop her in as a co-conspirator on the deception. But obviously, I don't know exactly. I mean, I don't have your complaint in front of me. I haven't spent any time looking at it, but it sounds like you've done the right approach.
Right.
Yeah.
If you ever want to get on Pacer and take a look at it, it might be
You can
worth a read. It's
You-
got to, they. I mean, it's
you can
that's
email
another thing I
it.
wanted to ask.
You can email it to
Yeah.
me.
I will. I also was contacted by a gal who had requested that I do an interview with her about what happened to me, and she's, I don't know if it's so much a news thing, but she said that it would be put on the news, and I don't know if that's something that is wise for me to do right now. What is your opinion on that?
Have you gotten your kids back? I don't remember.
Yes.
And is your case closed? The social workers are out of your life?
Oh, yes, absolutely.
The only thing you have pending is your civil lawsuit?
Yes.
Just recognize that whatever you say to the media, especially on camera, is an admission, right? Whatever you say it's going to come in against you at trial. So just be careful what you say. Don't say something that's going to hose your case.
Right.
But other than that,
Okay.
I mean, I don't know that I would necessarily have a problem with it. Just be aware that the other side is watching, and they will, if you slip up and say something that hurts your case, they will take advantage of that. And they'll be allowed to, because it's you talking, and anything you say can and will be used against you.
Right.
So, just be aware. That's all. I'm not saying...
So again, with
I'm not saying don't do it. I'm just saying be aware of the pitfalls.
I'm just kind of nervous about even not so much them, because they know that they did wrong, and I don't think there's really anything that I could say that would really make it they could use against me. But
Yeah.
it's my personal, I guess, just other people. There's still people that don't even know that I was involved with CPS.
Oh, well, then they're definitely
so-
all going to know if it's on the news.
Yeah. So that's kind of been a thing holding me back too. But with that, the medical records thing. So every time that I request that to be corrected and they don't do it, is that a new cause of action, or is that a continuing tort? How is that?
I don't know. I don't know. Potentially, I would think that you've got maybe a state remedy or a remedy in state law. You might be able to, sue to get some sort of declaratory judgment to force them to correct your medical record. But, I mean, I don't know. That'd be a Montana state law issue.
Okay.
But, you might research that.
Sounds good. That's all I have. And I'll
Okay.
email you over that complaint when you have some free time. You can take a peek at it.
Yeah. Whatever you email me, I'll eventually look at it. It's probably not going to happen anytime in the next 2 weeks. I'm just swimming in shit, but, it will happen.
Right, sounds good.
Cool. Well, nice
Thank
seeing you
you.
here again. Thanks for
Yes.
joining us. It's been a while.
Right? I will hopefully soon the judge I'll see something. I've been checking Pacer every day.
Yeah, well, let us know when you get something.
Oh, I will.
Cool. Yeah, you could share it up, whatever it is. I don't know how to do that on Discord, how to publish it. We'll have to ask James. But yeah, I'm
Yeah.
kind of interested to see it when it comes out. Cool. How about you, Nigel? You got anything to say?
Can you hear me okay?
Yeah, you're coming through loud
Yeah.
and clear.
All right. We just filed our first amended complaint on Friday. Essentially, my case was wrongful removal and judicial proceedings and malicious prosecution, all based off of an allegation of shaken baby syndrome, and even the treating neurosurgeon disagreed.
Mm-hmm.
And after a whole lot of 3 years of hell, everything got dismissed and dropped, and we even got our names taken off the child abuse registry, which is
Oh, nice.
obviously extremely rare.
Yeah.
Going from a prosecution to, not even on a registry.
Yeah, that's a big victory.
Yeah, so the judge, had his order and opinion last month, and most of everything went forward, especially with regards to the kids. But there's things, like state actors, some of the hospital employees, or conspiracy or Monell or failure to train that had to be alleged further. So we did that and filed that off. So
Okay,
kind of
good.
waiting around.
Good. That sounds good, man. So you didn't get blown out on anything with prejudice. They gave you leave to amend everything.
Correct.
Nice. So if you could email me your complaint, I'd love to see it. Your amended complaint. I mean, the one that you just recently filed.
Sure.
Yeah, you have the email, right? It's the capsandStemslaw@gmail.com. Or actually, you could send it more directly to me at cpslawyer@gmail.com. That's Charlie Papa Sierra Lawyer, like Child Protective Services Lawyer @gmail.com. That goes actually directly to me. That won't get filtered through James.
Okay.
But yeah, that'd be great. So when did you serve that? That was fairly recent, right?
Served the lawsuit, like filed the lawsuit?
No.
Or served the first amendment complaint?
Yeah, your amended complaint.
That was filed on Friday.
Oh, okay. Cool. So it's too soon to get their motions.
Yeah, so I guess I'm just going to be looking through everything you have on Patreon as far as motions to dismiss for similar
There's
cases.
a bunch.
I mean,
There's
we have a
bunch.
smorgasbord of causes of action. There's, 18 plus, I think. So,
Oh, Jesus Christ. That's a lot.
yeah.
So you must have state law claims in there too then, right?
Yeah, federal law, state law,
Yeah.
like informed consent, forensic exam claims, just a lot of stuff.
Hey, for the forensic exam stuff, you'll want to take a look at Swartwood, Mann, Wallace.
Yeah, Man vs. San Diego is a
DC.
big one.
Yeah. There's a whole bunch of those cases down here in San Diego. I've got another one I'm doing right now on their fucking consent form. I'm writing the summary judgment motion. It's due on the 17th. The judge ordered us to file cross motions for summary judgment regarding the efficacy of their consent form. I say it's vague, ambiguous. We don't know what the hell we're consenting to or when or how. The county says, no, it's totally, absolutely adequate, and we use it in every case, and it's not constitutionally violative of anything. And the judge, after our E&E, ordered us both to brief summary judgment motions, and she's going to decide who's right. So let's see when that hearing is. So I may have good or bad news. I'm not sure, but I should have a result on that sometime the first week in January, because she's taking it under submission on the 23rd, and I have a feeling that she's already kind of got an inkling one way or the other. Otherwise, she wouldn't have ordered us to do it. So I think she'll get her order out fairly quickly. So I'll get that all published up on Patreon as soon as we have it.
Yeah.
What do you anticipate her inkling is?
I don't want to handicap it.
Okay.
Yeah. I don't know who listens or watches this stuff. James will put this whole recorded thing on next week, and I don't want to handicap it. So
You mentioned earlier a failure to protect documentary.
that was who mentioned that? It wasn't me. It was maybe Laura or Michelle. It was Michelle.
Okay. I have to look into that.
Yeah, I think it's on. I want to say it's on like Amazon Prime or something.
That's where I watched it.
Yeah.
Oh, great.
Yeah, I think he's going to do another one, but I'm not sure. I think Bob Powell was in that too. I think Bob Powell, Vincent Davis. I did an interview. I don't remember if Donnie Cox did one or not. I think not. But I don't know if you guys have been following that Take Care of Maya case, but the verdict came out $220 million, man. That was pretty.
Back.
That was pretty big news.
I cried.
Yeah.
Wow.
Yeah, it was a big.
I think it was even more than that. I think it was like 211 million and then 50 million in punitive damages. So it exceeded
Yeah.
Yeah.
Yeah, I think it was 220 million for the compensatory. That's the last time I looked at it, and they were going into the punitive damages phase when I saw the news on it. And so I haven't looked back since then. But if they did 50 million in punitive damages, that's freaking crazy, man. Those guys, I guess the jury was really pissed off. You know, whatever happened there, the jury was very angry.
I was listening. I've been watching the trials on that, and the jury's been asking a lot of questions that made me think that they were going to go with the plaintiffs on this one. And a lot of the time, the defense counsel kept on bringing up how they wanted to move for a mistrial on it.
Yeah, I think that what the normal process is, I don't know how many of you guys followed that. What the hell was the name of the case out in San Bernardino? Is the kid where social services actually should have taken him but didn't, and then the girlfriend ended up nearly beating the kid to death and causing a bunch of brain damage. Really horrible, sad story. They got a $110 million unanimous jury verdict. The judge took the whole thing away on a motion for judgment not observing the verdict. They appealed it, and the appellate court upheld the judge's decision on the motion. So it was like, fuck. You know, it was a great verdict, but it got taken away. And that's what usually happens on these ginormous verdicts. But again, I don't want to handicap it, especially somebody else's case. I wasn't there. I haven't been following it. I don't know what the jury did or why. I don't know what the evidence is. But my gut feeling is on a verdict that large, it's either going to get remitted on a new trial motion or taken away completely, or it's going to get, taken away on appeal. But it's very, very rare that on one of these types of cases, the trial court or the appellate court is going to let that thing stand. But it still sends a really powerful message. I mean, either way, it's letting all these fuckers know that juries don't like it when you get around and start screwing with families. But says, Sean, I know you have to go soon, so I'll just type this. Maybe you can think about it. Wondering about finding a social worker to county or state from the overflow family services to individual services stemming from decentralization due to ACA. I don't know. I don't even know I don't know what you mean, actually. But
Hey, really quick, remember the Amy Sanchez depot?
Yeah, she was with for the upfront assessment. I forget the name of the company that they were with, though.
Right, so she was saying how everything the overflow gets streamed out to different units. I don't know
Yeah,
if you remember that?
yeah, vaguely.
She said from decentralization because of the Affordable Care Act.
Yeah,
That's what she said.
Yeah, I
So I was
don't
wondering-
remember, but yeah, I'm not doubting you. I just don't remember.
No, I get it. I'm just wondering if it's possible to follow the money in a way or bind the person to the county or state from overflow services.
Not on the third party. Well, can you? I don't know. Third party, if they're getting paid to do these upfront assessments and they do something fraudulently or falsely or whatever, maybe. I mean, I could see that argument. I could see somebody making that argument. I don't know whether or not it'll fly, but I mean, it makes logical sense.
Yeah, I'm just thinking of ideas.
Yeah. I what I would do is just try it. They'll tell you if the defendants will tell you if they think you're wrong and why, and then you'll have a first point of departure for your opposing research. That they'll kind of tell you what issues to go research. That's how it always works on our stuff. When I try a new claim, figure okay, well this makes logical sense to me. And then the other side comes out with whatever bullshit argument they have, and they'll have a bunch of cases. And that gives me something to focus on then and say, okay, well, how am I going to counter what they're saying? And then you go research, look at their cases, look at other things that are similar arguments. but that'll give you, sort of a first point of departure to do new research on a new issue. But that's how I build them. It's kind of hit.
Thank you.
Yeah, it's kind of hit or miss. It's an iterative process.
Irritative. I haven't heard that one. Like irritable?
No, iterative. Like you iterate on it. You try something, doesn't quite work, tinker with it, try it again, doesn't quite work, but gets closer, tinker with it, try it again. You iterate. It's a bunch of different
cool.
iterations. Yeah.
And the last thing was, what if they say that they don't have any medical records because they don't take notes?
They do that all the time.
Okay.
They do that.
That's true?
That I don't know if it's true, but they say that kind of shit all the time. I face that in almost every case. Oh, I shredded my notes. It's like, well, why the fuck did you do that? It's just our practice. It's like, well, okay.
Got it. Thank you.
Yeah. With that, I'm going to have to cut it out, guys. It's 6:08. I actually had to get on the road by 6, so I'm kind of in a rush. I hate to cut it abruptly, but I got to go, man. So thank you all very much for joining us tonight, and we'll see y'all hopefully next week. In the meantime, have a great week, and stay safe out there.